We've taken new decisions to enforce public health rules. We cannot accept that a majority of people pay for the negligence of a minority. We cannot receive people in our homes in red zones. If you're inviting guests for a party, you're breaking the law. When this happens, police officers can give fines of $1,000.
It's always a good afternoon and great company. Montreal Now with Aaron Rand on CJAD 800.
Trudy Mason sitting in for Aaron Rand these weeks. And you remember those dark, dark days we were having dozens upon dozens of COVID deaths every day. So many people so very worried about getting sick. And then the government decided it would impose fines for certain types of behavior that it felt were working against public health. So of the $68 million in fines the provincial government issued during the pandemic, by now, about a third of it has been recouped. In other words, the people who were issued the tickets paid up. There were 44,000 tickets issued in all. About 17% of the people who were ticketed pleaded guilty, paid the fine. 41% ignored them and may eventually end up having to pay. 42% pleaded not guilty, and the cases are still wending their way through the system, including a significant challenge of the COVID-era laws. Fighting the man has not paid off in a lot of cases. The conviction rate for the people who tried to fight their cases is 85%. But again, one of the laws underpinning those fines is being challenged. And here to tell us more about these fines, Olivier Seguin is a lawyer for the Justice Center for Constitutional Freedoms. Olivier, thank you for joining us on Montreal Now.
Thank you for inviting me.
What do you make of the 42% not guilty plea rate? Why do you think it's so high in the cases of these pandemic-related fines?
I must say that I was surprised to learn that it was as high as that. 42% is very, very high. So I cannot give a definite answer. I have some sort of hypothesis. I received, I would say, several dozens, although not hundreds, of emails of people wanting to know more about, basically about our case. They might be waiting for a decision to be rendered that will say that the curfew was illegal and or unconstitutional. That's possible. That being said, there might be several other people who just think that they had a good reason in their case to basically not to be found guilty, and some others might simply just plead not guilty and wait and see, think that perhaps time goes. Time basically runs for them, works for them.
Is it ever a good idea, though? I'm thinking of the 41% who just ignored the fines. Is it ever a good idea with any type of a fine to just kind of ignore the notices you're getting? And
that's never a good idea. Never a good idea. Ignoring it, it basically transforms, let's say, a baby dragon into a big dragon. The fines can be doubled, and it can really snowball. It's not good.
The conviction rate for the people who have fought their case so far, because a lot of these cases are still up in the air, the conviction rate has been 95%. Is that also high in your view?
I wouldn't say that it is that high, in the sense that it's not properly criminal. It's not that kind of law. It's penal, but it's not criminal. So it's like let's say burning a red light. It's hard to have a defense. Like most of the time, there might be cases where you have something to say, But in most of the time, like if there's the proof that you did it, there's not much to say. So I wouldn't say that it is that high for that type of conviction.
Now, tell us about the challenge that you're involved in, which is really going after the justification for the curfew laws. On what grounds are you challenging the law?
That's right. So I don't want to go too far into the nitty-gritty because it might not be the time, and I will not have the time. But basically, we didn't challenge our proceeding is not about, in the first place, challenging the constitutionality of the curfew. What happened is that we defended a client that was fine, and in the course of their defense, we challenged the constitution of the curfew. Technically speaking, and I'm saying technically speaking, it means that if we win, it should be only a win for our clients. That's technically speaking, and that was true in the Court of Quebec, which is an inferior tribunal. But since we appealed it in the Superior Court, if we win that time, this will make a precedence. And so it will not be only our client who will be judged not guilty, but it would be basically everyone that was fined for the curfew.
When will Quebec Superior Court hear the case, or is it being heard now?
The two memorandums have been deposited to the court, so the file is pretty much together. And we don't know at what date yet it will be heard. I suspect that it would be surprising that it would be heard before 2025.
Oh, my heavens. Okay,
yeah.
So we're talking still months to wait to get a decision. And can you just briefly, in a couple of sentences, tell us what your argument centers on in terms of challenging that curfew law?
Sure. So let's say a few sentences. At the beginning, we were going to say that it was unconstitutional because the basically Arruda, so the Minister of Health, didn't have public scientific data to basically to back the fact that a curfew works in terms of contamination. So we subpoena Horacio Arruda, and they responded by having basically his right arm, who back then was the sub-minister of health, and he said in trial, and we were surprised. So we weren't ready at the time to have this sort of admission, but he confessed, and he was very honest about it. So much to his credit, that one of the principal objectives of the curfew was basically, in his word, sending a message. Sending a message, which means basically exercising discipline over Quebecers basically to enforce all the other measures that they were putting in place.
And that is something that's not allowed under public health law, correct?
That's it. Under public health law, first of all, it doesn't speak per se about a curfew. It grants the power to do all sorts of things, but all those things are directly linked to basically stopping a pandemic in terms of stopping the transmission. For example, and it goes far. For example, it gives the power to order vaccination, which is something. It also gives the power to confine. And one can say that indeed the curfew is a sort of confine, but the reason that it was adopted was at least one of the reasons why it was adopted was basically it was disciplinary. So it was not to stop the contamination in the community. It was disciplinary, and nothing of the sort is in the public law. So we say that it was illegal. It was not authorized by the public law, the Public Health Act. I mean, and if it could be done, it couldn't be done under that law. It perhaps could have been done under the I have it in French, La Loi sur la Sécurité Civile. So I guess the
public safety law. This is going to be a very interesting case to watch. We're up against traffic. Olivier Seguin, thanks for your time. I appreciate the interview.